That's one of the things that's hard for me about this case is, let's posit that I agree with you about Facebook and YouTube and those core social media platforms. Don't we have to consider these questions Justice Alito is raising about DMs and Uber and Etsy, because we have to look at the statute as a whole? And I mean, we don't have a lot of briefing on this, and this is a sprawling statute, and it makes me a little bit nervous. I'm not sure I agree with you about DMs and Gmail. Just, it's not obvious to me anyway that they would, that they can't qualify as common carriers.
Look, I agree. You don't want to decide all of that today,
yeah.
But this is not here on sort of final judgment. It's here on a preliminary injunction. And the question is, do you want this law, with all of these unconstitutional applications, enforced by every Floridian? So these provisions are enforced by every Floridian being able to go into court and get $100,000 in civil penalties. Now, do you want that completely antithetical law to the First Amendment to go into effect while we sort out all these anterior questions? Or do you want it to be put on hold while we can litigate all of this stuff, and if it turns out there's a couple of applications that are okay, or somebody wants, a briefing just on the question of whether direct mail is a common carrier?
Can you escape that in this posture?
Absolutely, you can escape that in this posture. You affirm this preliminary injunction, which is in place. If you want to, you can point to the clear litigation judgment that Florida expressly made below, which is, we're not going to get into all of that intermediate scrutiny stuff. We don't want a record on that. We're going to put all our eggs in the expressive activity basket, and they could not have been more clear about that below and in the 11th Circuit. And then you say, this law, which has all of these First Amendment problems, this wolf comes as a wolf, we are going to put that on hold, and then we can sort out some of these tertiary
Well, if that's the case, Mr. Clement, to what extent is it the result of your own litigation decisions? You could have brought an as-applied challenge limited to the two platforms that you want to talk about, Facebook and YouTube. But instead, you brought a facial challenge, and you claim that it's also susceptible to analysis under overbreadth. So you had to get a preliminary injunction, you had to show you had a probability of success on your facial or overbreadth challenge.
And we did.
And you can't now shift and say, it was a good preliminary injunction because it's fine as applied to the platforms I want to talk about, and let's forget about all the other platforms that might be covered.
Well, Justice Alito, first of all, we did all that and we won. Second of all—
Did you bring an as-applied challenge?
No, we didn't bring an as-applied challenge because we think this statute is unconstitutional in all its applications.
Exactly. And so